Thank you so much for coming out today. My name is Regina Austin, and I'm the William A. Schneider Professor of Law and the Director of the Penn Program on Documentaries and the Law. And I want to welcome you to Penn Law School, and I want to welcome you to the inaugural Documentaries and the First Amendment lecture. This is a series which is sponsored by Stephanie Bruton, who will introduce our guest lecturer. Did I get the name right? Very good. Stephanie is a member of the Penn Law class of 1991. She is presently Senior Vice President and Chief Counsel for Litigation for Home Box Office, Inc. She is responsible for the full range of legal issues and proceedings arising from the operations, distribution, and programming of HBO. She also oversees HBO's litigation group and anti-piracy program, and you can imagine how busy she has been this week. If you've been following what's going on, particularly with regard to today's subject, I have to say she hit the nail on the head with the topic that we are presenting for the first of this lecture series, sponsored by her, and I want to thank her for doing that. Prior to joining HBO, she served as senior counsel, East Coast Media for the Tribune Company. So she's multimodal with regard to her interests. We're big into multimodal scholarship and work here at the law school and in the documentaries program. And she is currently on the New York State Bar Association Media Law Committee and is a member of the governing board of the ABA Forum on Communications Law. She is also an adjunct professor of media law at Cardozo School of Law. And we'll see what we can do about that. Stephanie.
Thank you very much. Thank you, Professor Austin, for launching the Documentaries in the Law program here. It's really a wonderful, wonderful thing. Thank you all for coming today. We appreciate it. I could stand here for about the next 20 minutes talking about Ted Boutros, but instead I'll try to make it very brief. He is a partner at Gibson, Dunn & Crutcher, currently in their Los Angeles office. Ted is co-chair of the litigation group, and at various other times has been chair of the appellate group, the crisis management group, the media group, and I think there's some others in the list somewhere on the website as well. What you won't get from reading his bio on the firm is that for many, many years, Ted has been the go-to lawyer for media companies who are facing thorny First Amendment issues. He is an equal opportunity litigator. I first met him in the 1990s when I was working for ABC Television and Ted was at Gibson Dunn representing a lot of other media companies when we were jointly seeking to open up the grand jury proceedings surrounding the Bill Clinton-Monica Lewinsky litigation. More recently, Ted represented CNN and its reporter Jim Acosta in suing the President Trump and the administration to get Mr. Acosta's press pass returned successfully, I'm happy to report. And a whole lot of other stuff in between. He is, among other things, representing Ashley Judd in her lawsuit against Harvey Weinstein, which makes him, given his First Amendment scholarship and his representation in that case and some others that I'm sure he'll talk about, the perfect person to talk about the subject at hand today. Ted is a brilliant strategic thinker. He's an all-around nice guy, and he is a prolific tweeter. If you're not following him on Twitter, I recommend you do so at Boutros Ted. And Ted is also the first lawyer who volunteered to represent pro bono anyone who got sued by President Trump for speaking out, which I don't think has actually happened, even though it's been threatened a lot. So without further ado, I will hand the microphone over to Ted.
Thank you, Stephanie. Thanks so much, Stephanie. It's really great to see you again. We've been in the trenches together on First Amendment issues for a long time. And Professor Austin, thank you very much. The program is very impressive that you've got going here. The timing couldn't be better for this topic, defamation, and whether it's today, and whether it's an instrument of vengeance or vindication. There's really been an explosion of defamation claims in this country, particularly over the last couple of years, starting a little bit before the 2016 presidential election. There's also been an explosion of speech in the world, in part because of social media, the internet, and there has been just much more vigorous litigation over speech. The United States, of course, is a nation that is built in significant part on freedom of speech and freedom of the press, and we have strong protections in the Constitution and in the law that's meant to foster free debate and free speech. But there are limits, and as most of you, probably all of you know, state law generally includes a number of civil cases, torts that can be brought directed at speech. There are things like intentional infliction of emotional distress. There's a tort called interference with business relations. There's privacy-related torts. And, of course, defamation, which is also known as libel. And a plaintiff in those sorts of cases can seek not only compensatory damages to remedy their harm, but also punitive damages to punish the speaker for a false or malicious statement and to deter future false speech. So tort law is in some ways, when it's invoked with respect to speech, actually meant to deter and chill speech. That's the purpose of the tort. So it can create real First Amendment dangers. The damages can be astronomical. I once represented the Wall Street Journal in a defamation case where it's still the largest verdict, I think, ever, anywhere. It was a $222 million verdict against the Wall Street Journal. We were able to get it overturned, but you can imagine the chilling effect, the deterring effect of speech for companies and news organizations and reporters to see that that's a possibility in a defamation case, that there could be such a huge, huge award. And even for wealthy, powerful news organizations, let alone the lonely pamphleteer, the blogger, the Twitter impresario, the filmmaker, the documentarian, to the fact that you could be sued and potentially have a multi-million-dollar or even bigger verdict can be frightening. In this lecture, I'm going to focus mostly on defamation law, but most of the principles and issues that I talk about can come up in any kind of tort suit. The definition of defamation is pretty simple. It's generally the making of a false statement of fact about someone that harms their reputation, that defames them. And that can produce economic loss to your business. It can produce emotional distress, other types of harm. And as I said, the damages really, there are no limits in the law as a general matter. It's supposed to be the amount necessary to compensate and sometimes to punish. In 1964, the Supreme Court, in a landmark decision called New York Times versus Sullivan, found for the first time that the First Amendment to the United States Constitution imposed limits on state civil tort claims for defamation. And the court held, in a case that really is a bedrock of our law, that a plaintiff, a person who claims they've been defamed, who's suing a public official, and that was later expanded to be a public figure, must meet a particularly high burden as a matter of First Amendment law. The plaintiff has to show not only that the statement was false, that it was harmful or defamatory, but also that the reporter or news organization made the statement with what's called actual malice, with either knowledge that the statement was false or with reckless disregard for the truth of the statement. It's a very, very potent protection. It's a very, very difficult standard to meet. In fact, the court also said that there has to be clear and convincing evidence of that actual malice. But the First Amendment and speech and free press are under attack in this country from the very highest levels of our government, including led by none other than President Trump, who has called for an opening up of the libel claims, of the libel laws. One of his planks during the campaign was that he thought that the libel laws should be opened up and it should be easier to sue for defamation. And he has also repeatedly branded journalists, including my client CNN and Jim Acosta, as enemies of the people. He's labeled news as fake. And in the past few years, we've seen this culture of hostility and antagonism towards the rights of freedom of expression, with journalists being assaulted, murdered. We had the Jamal Khashoggi murder that the United States still hasn't really condemned. And there's been a ripple effect around the world when I think other countries see that the United States, a beacon of free expression, is not taking a hard line on these issues and not protecting rights of free speech and free press. We've had journalists, including CNN, targeted with pipe bombs, with people who are getting riled up by all this talk about journalists being evil and bad people and enemies of people. And then just last week, perfect timing for my remarks today, Justice Thomas on the U.S. Supreme Court, out of the blue, issued an opinion concurring in the denial of cert, which means that he agreed that they shouldn't take this case that was a defamation case against Bill Cosby, but he nonetheless issued an opinion that called on the court to, in some future case, re-examine New York Times versus Sullivan and all the First Amendment protections that have been established that protect freedom of speech and free expression. And it sent shockwaves through the First Amendment world and the Supreme Court world. So we have that to talk about, and we do it against the backdrop of the fact that there really is an ill wind blowing in the face of freedom of expression in this country. And really the number of defamation claims by powerful figures, by unknown people, but the sheer volume that have been filed in the last 2 or 3 years is remarkable. For many years, because of the strong protections of Times versus Sullivan, libel suits had gotten less and less frequent because they were so hard to bring, particularly against particularly if you were a public official. So if you were President Trump or a famous person, the standards are very difficult to meet, but suddenly things have started to change. And I submit that defamation claims, libel claims, and all of those torts are being used to a significant degree for vengeance and to intimidate people from speaking out, to intimidate reporters from reporting on difficult stories about powerful figures, political figures, people in the entertainment industry, everywhere. And so it's a real danger. And that includes the Me Too movement and the women who've spoken out, the journalists who've written about what happened to those women. And so there's a real, the topic could not be more timely. At the same time, while I feel very strongly that we need to protect freedom of speech and freedom of the press, and we need very, very strong protections under the First Amendment to defeat libel claims, I'm currently representing, as Stephanie mentioned, a plaintiff, actor Ashley Judd, in a defamation claim against Harvey Weinstein. And so you're probably thinking, how can he reconcile these two things? And I will demonstrate that I think it's pretty easy. That there is a place for defamation law in civil tort law to vindicate important rights that doesn't really pose any type of danger to the First Amendment. And over the years, I've stepped back, and I think in the First Amendment bar, there has always been this sort of just notion that any defamation claim is bad. And my mantra these days is most of them are bad, but sometimes you can see a place where the law really is important to protect people's rights, and I think my case for Ashley Judd does that. So let's maybe we'll start with a little bit of a stage setting with Times versus Sullivan. As I mentioned, it's a very important decision. I think it's one of the most consequential and important decisions in our history and in the Supreme Court's history. The case arose during the Civil Rights era in the 60s, and it rose directly from the Civil Rights movement. And it was during the period of the Warren Court, which I'm sure you all know was viewed as a politically liberal in a sense, but liberal in the sense that it was expanding civil rights and civil liberties in a dramatic way, in an important way. the Times versus Sullivan case arose out of an ad that you'll see up there on the screen, Heed Their Rising Voices, that had been sponsored by the Committee to Defend Martin Luther King and the Struggle for Freedom in the South, and a group of celebrities and religious leaders that was really just advocating protection for the civil rights movement and for demonstrators. L.B. Sullivan, a city commissioner from Alabama, sued the New York Times and others for defamation. He claimed he was defamed by this ad. And he won a $500,000 verdict, which in 1962, whenever it came out, was a big verdict. And the Alabama Supreme Court affirmed it. And so you can see the fact pattern where you've got the New York Times publishing something that is supporting the civil rights movement, and you've got a jury in Alabama punishing them in a sizable verdict. It really was a significant danger to reporting and other publications and speech about a critically important issue to the country. So from a First Amendment advocate perspective, it was a great case to have go to the Supreme Court. The Supreme Court unanimously reversed the judgment in an opinion authored by Justice Brennan, who was appointed by a Republican, but who became a liberal lion on the Supreme Court. The court ruled that the judgment had to be reversed because the plaintiff there, Mr. Sullivan, had not proven actual malice. And the term had never been used, actual malice, until this case. And the Supreme Court spoke in sweeping terms as to why this standard, which required not just falsity, not just defamatory content, but actual malice, either knowledge that you're making a false statement or reckless disregard for the truth. And the court explained, and I'll just give you, I have one of the quotes up here, it's one of my favorite, and it's repeated in many, many Supreme Court decisions. But the court talked about the rationale for applying the First Amendment to regulate state litigation, which was fairly extraordinary at the time. And because we have a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government officials. And that really, if you think about it, that's America, that's the Boston Tea Party, that's what we're all about, is challenging power and the people being able to speak out and have the information they need to do that. So the court went on and made multiple statements that really are for the history books and really so part of our culture as a legal matter and a political matter. The court said that erroneous statements are inevitable. They're going to happen, and we need to have a high standard before we allow a civil claim targeting even an erroneous statement, because there has to be sufficient breathing space so people don't worry, well, if I get it slightly wrong, can I be sued? If I'm a newspaper, can I be put out of business? The court talked about how civil damage awards, like this $500,000 damage award in New York Times versus Sullivan, could dwarf a criminal fine and therefore could impose even more of a fear. The court called it the pall of fear and timidity imposed upon those who would give voice to public criticism in an atmosphere where you could be punished for your speech. So for all those reasons, the court said, we are finding as a matter of First Amendment law that there's this higher burden. And it was a 9-0 decision, unanimous. But 4 judges concurred on the ground that the court should have gone even farther. They said we should just say there's absolute protection when you're talking about a government official. Those were really the days, for First Amendment moments. 4 just, how can we even oppose this actual malice standard? So it was a very important decision, and it forms so much of what our democracy is about today, outside of defamation even. Through the years, the Times versus Sullivan decision was expanded. It was expanded to cover not just public officials, but public figures as well, famous people who are known to the public and in the public eye. It was expanded to cover private figures who were seeking those punitive damages I mentioned, where they're seeking to punish speech. And it was expanded beyond the tort of defamation to cover other torts. And my favorite case in that area, because it proves a number of the things I'm going to try to demonstrate to you tonight, is the Hustler Magazine versus Falwell case. A couple things about the case are interesting. It involved Hustler magazine, sort of notorious magazine. It involved Jerry Falwell, who was a well-known Christian fundamentalist and conservative political commentator. And Mr. Falwell sued Hustler because Hustler ran a parody ad in one of its magazines that it was based on the Campari ads that were running back in the day. And it showed his photo, as you see, and his name, and included a clearly fake interview with him where he discussed a drunken, incestuous rendezvous with his mother in an outhouse. And there were descriptions that this was a parody. So it said on the face, this is a parody. But he nonetheless sued, even though the jury would ultimately find that everyone would have known, or no reasonable person would have not recognized that these were not statements of actual fact. But Mr. Falwell, who was, if you remember Jerry Falwell, there was no shrinking violet. I mean, but he sued saying this was so outrageous that it caused him emotional distress, and it was an intentional infliction of emotional distress. The Supreme Court unanimously reversed again. To me, what's remarkable, particularly when we juxtapose it with Justice Thomas's concurrence last week that I'm about to come to, this unanimous opinion was written by Chief Justice Rehnquist, who was a conservative icon. He was sort of Justice Scalia and Justice Thomas before they rolled onto the scene. He was the justice who would write the provocative dissenting opinion before he was the chief. He was the justice who would say, you know, we've got to stop being too creative with the law and stick to what the Constitution says. But the chief writes an opinion for the court, unanimous court, that says just because you label the tort intentional infliction of emotional distress, the Times versus Sullivan actual malice standard still applies. And he did it, by the way, he was joined by Justice Scalia. So Justice Scalia had just come on the court, again, viewed as an ideological soulmate of Justice Thomas, but Justice Scalia joins Hustler magazine in 1988. And they say, the chief writing for the court, the chief who's basically the ideological opposite of Justice Brennan, who wrote New York Times versus Sullivan, they say that, you know, that we must apply the Times versus Sullivan principles in this context, and they use the same sort of ringing language that you see in Times versus Sullivan. The court said the sort of robust political debate encouraged by the First Amendment is bound to produce speech that is critical of those who hold public office or those public figures who are intimately involved in the resolution of important public questions. The court said that one of the prerogatives of citizenship in our country is the ability to speak freely and criticize government officials and political figures and public people with power. And the court went on, I think that Chief Justice Rehnquist liked this party catalog historically how political cartoonists had issued these caustic, sometimes offensive cartoons about political figures, and he said that that had played a prominent role in political and policy debate in the country. So for that reason, the court said the same actual malice standard applied to a public official or public figure who was suing based on speech they claimed caused them to suffer emotional distress. And the court said, this isn't just some blind application of Times v. Sullivan. It is, quote, it reflects our considered judgment that such a standard is necessary to give adequate breathing space to the First Amendment. So this was huge. Now you've got, this is not some anomaly from the Warren Court, which at the time there was a war on the Warren Court still going on that became a political issue, that the Warren Court had gone wild and there was judicial activism. But this was the Supreme Court under Chief Justice Rehnquist. So along comes, I'm sitting at my desk minding my own business, and all of a sudden Twitter explodes, and Justice Thomas has issued this opinion saying that Times versus Sullivan should be overturned. And as I said, the good news is that it wasn't an actual decision. It was only Justice Thomas writing for himself. Nobody joined his opinion. And the case, I'm going to talk a little bit more about the actual merits of the case when we dig in. It was a libel case by Ms. McKee, who sued Bill Cosby, claiming that he and his lawyer had defamed her when she came forward and said he had engaged in sexually inappropriate behavior with her. And the Supreme Court did not take the case up. And nonetheless, Justice Thomas took the very unusual step of writing his own 10 or 12-page opinion, where he argued, based on his originalist view of the Constitution, that we need to go back to square one and see what the framers of the Constitution believed. Would they have thought that the First Amendment governed libel claims? And he pointed out correctly that the Supreme Court had never applied the First Amendment to state law defamation and libel claims until Times versus Sullivan. But he argued that we should take a fresh look, and if the Constitution and the framers did not require public figures to satisfy an actual malice standard in state law defamation suits, then neither should we. But that view would radically alter how our country has really developed in the last half century. As I said, we're built on the notion that these principles protect free speech by us about government officials. And Times versus Sullivan stands for the proposition that we need breathing space, we need room. Once in a while there's going to be an error, but when you're talking about public issues, about public officials, there needs to be the ability to speak out without fear that a powerful government official or celebrity or business person or anybody can sue you and put you out of business, put your family out of business. That would be such a deterrent. And I don't think that the Supreme Court's going to do that they're going to agree with Justice Thomas. As I said, the decision is embedded in the fabric of our democracy. None of the other justices were attracted to it. It doesn't meet any of the standards for overturning a Supreme Court decision. But the mere fact that a Supreme Court justice would, sort of spontaneously, on his own, issue that sort of opinion is chilling. And I think it should put everybody on guard that there's something going on that we need to be watchful of to make sure that freedom of expression and of the press is protected. And Donald Trump embodies, he's my symbol. And I'm not going to be political because I don't mean to be political, because President Trump has been explicit about what he thinks about journalism and the First Amendment and freedom of the press. As I mentioned, in the campaign, by words and deeds over and over again, in part, one could argue it's one of the reasons he became president. It's just a fact that he was speaking in a way that lashed out against the media elite and by definition, sort of open, robust journalism that's vigorous. And so it's not really me saying it, it's what he has said. And he is, in the campaign and even after his election, argued that we should open up and loosen up and change the libel laws. And I'll just play you a clip so you can get a sense, if you can't remember how it sounded. Here's what he said during the campaign.
I'm going to open up our libel laws so when they write purposely negative and horrible and false articles, we can sue them and win lots of money. We're going to open up those libel laws so that when the New York Times writes a hit piece, which is a total disgrace, or when the Washington Post, which is there for other reasons, writes a hit piece, we can sue them and win money instead of having no chance of winning because they're totally protected. You see, with me, they're not protected because I'm not like other people, but I'm not taking money. I'm not taking their money. So we're going to open up those libel laws, folks, and we're going to have people sue you like you never got sued before.
So for him, Justice Thomas's concurring opinion in denying cert was like music to his ears. I mean, everyone said, well, how can you open up the libel laws? There's Times versus Sullivan. So the timing is a little bit scary. In addition to calling for a change in the libel laws, you may remember during the campaign, after the infamous Access Hollywood tape was released, over a dozen women came forward and accused President Trump of engaging in the kind of sexual misconduct that he was bragging about on that video with respect to them. And in connection with that, then candidate Trump, in his Gettysburg Address of all places, it was on October 22, was there to give a speech about, I presume, something involving the fine state of Pennsylvania and Gettysburg. But instead, he went off on a detour and vowed to sue all the women, private citizens, who had great risk to themselves. And again, I don't mean to be political, and you can You can agree with them, believe them or not, but as a First Amendment matter, these were private citizens in the middle of an election for the presidency when the protections for free speech should be at their zenith, that citizens should be able to speak during that period, as President Trump did, with everything they have. So here's what President Trump, and I'm sitting on my couch with my wife, it was a Saturday morning, President Trump.
Every woman lied when they came forward to hurt my campaign. Total fabrication. The events never happened. Never. All of these liars will be sued after the election is over. But a simple phone call placed to the biggest newspapers or television networks gets them wall-to-wall coverage with virtually no fact-checking whatsoever. Here is why this is relevant to you. If they can fight somebody like me, who has unlimited resources to fight back, just look at what they can do to you. Your jobs, your security, your education, your health care, the violation of religious liberty, the theft of your Second Amendment, the loss of your factories, your homes, and much more. Look at what they've done to you with your jobs.
You have to give him credit. He took libel claims and defamation and accusations, and your Second Amendment rights and your factories are going to be gone. But he's creative. So I like to give him credit when he deserves it. That was good. But I couldn't believe it because you had the President of the United States, and President Trump, and I'll talk about this in a second, was known for threatening libel suits in order to deter journalists and to stop journalists from writing stories. And so as Stephanie mentioned, I tweeted that I would defend anyone who he actually sued for exercising their First Amendment rights. As a First Amendment lawyer, one of the most important things I think that I believe is that people need to know there's somebody there to defend them. And as a lawyer, your tweets don't get that much coverage. But this one got like 21,000 likes. It got 15,000 retweets. And lawyers from around the country, including Republicans, Democrats, said, we're with you. Well, this isn't a partisan thing. This is a First Amendment issue. And one of the things that I enjoy about First Amendment law is it really isn't a partisan thing. It's the First Amendment rights that allow someone who's critical of President Trump or of Nancy Pelosi. It applies the same to everybody. So everyone can speak out and participate. So I tweeted this, and I'll just do one digression because of Michael Cohen's testimony today. I tweeted this. I represented Natasha Stoynoff from People magazine, who had written a story about her encounter with Donald Trump back when she was writing a story about him. And he didn't sue her, but he was mocking her from the stage and claiming that she was a bad person, and she wanted to keep writing about it and talking about it. And so I represented her, but I became the person that anyone who wanted to sue Donald Trump called for a while, for at least up until the election. And I got a call from this woman named Karen McDougal, and she said she had a different problem, that she had had an affair with Donald Trump back in 2006, and that she was wanted to do an interview and wanted to tell her story, but the National Enquirer came in and offered her $150,000 for her life rights to any story that she had about having an affair with a married man. And then in exchange, they were going to run stories about her and in the magazine about fitness and other topics. So she'd agreed to do that. She liked Donald Trump. She didn't have an vendetta. She had been a Playboy model back when they met. But she had this agreement with the National Enquirer that said she couldn't talk about any of it. And it all happened right in the run-up to the election. And when I looked at it, I knew exactly what would happen. I knew that then candidate Trump was friends with David Pecker at the National Enquirer. I knew that Michael Cohen was sort of lurking around. I knew this lawyer. The Wall Street Journal at that time was circling around the story, so there's a journalism angle to this. And making sure that she was able to not violate that agreement, but that the Journal was able to report on it. They reported on that story, plus the Stormy Daniels, the beginning of the Stormy Daniels story that led Michael Cohen to have to plead guilty to the crimes, and they talked about that a lot today. So all these things kind of come together But part of it is just the ability. The reason I thought it was at least close enough to my tweet was she wanted to express herself and tell her story, and so I felt it was worth. I didn't want to back out of my agreement. The other thing about President Trump, and I promise I'm going to be done with President Trump in a minute. He's encouraged violence against journalists over and over again at rallies, and I think it's had an effect. So here he is. He's talking. You'll remember the Montana congressional candidate, Gianforte. When a reporter asked him about health care, he body slammed and broke the guy's glasses. And nonetheless, he won. So he prevailed in his election. Again, being mean to journalists isn't necessarily bad for your political prospects. But then he actually was then convicted of and paid a fine for a criminal fine. But President Trump,
But I had heard that he body slammed
celebrated it.
And he was way up. And I said, oh, this was like the day of the election or just before. And I said, oh, this is terrible. He's going to lose the election. Then I said, well, wait a minute. I know Montana pretty well. I think it might help him. And it did.
And you have that. You have the fake news label. So this was President Trump's first press conference right after the election. Oh, let me go back.
And since you're attacking us, can you give us a question? Mr. President-elect, go ahead. President-elect, since you are attacking our news organization, can you give us a chance?
Your organization.
You are attacking our news organization. Can you give us a chance to ask a question, sir?
Go ahead.
Sir, can you state, Mr. President-elect,
Go ahead.
can you state
She's asking a question. Don't
Mr.
be rude.
President-elect, can you give us a question?
Don't be rude.
You're attacking us. Can you give us a question?
Don't be rude.
Can you give us a question?
I'm not going to give you a question.
Can you state categorically?
You are fake news.
Sir,
Go ahead.
can you state categorically that Mr. President-elect, that's not...
So that was the fake news moniker denigrating. That was Jim Acosta, my soon-to-be client later in this story, going after it with President Trump. President Trump likes this, and it's somewhat entertaining. And again, the rough and tumble of reporters going at it with the president or with a political figure—that's what it's supposed to be about. But calling the best journalists in the world and the best journalism were fake news really undermines our process in this country for deciding important issues, because the public thinks, well, that's not real. I don't know what to believe, and can't make decisions. President Trump sued the author Tim O'Brien for $5 billion because he allegedly understated President Trump's wealth. This was before he was president. And he said that he legitimately didn't care whether he won. He sued Tim O'Brien. He lost, but he caused Tim O'Brien and his publisher to spend a lot of money on legal fees. So those, and since he's been in office, when the book Fire and Fury came out, Michael Wolff's book, he sent a letter to Michael Wolff and said his lawyer, Charles Harder, who you'll hear a lot about, is sort of the new, if you have a libel claim you want to file, you hire him, and he sends a really nasty letter and to try to scare you. But while in office, President Trump threatened to sue to stop the publication of the book and for defamation. He never did sue, but it happened. And then the Jim Acosta press pass issue, again, it's all part of a climate. I think you probably all know the story. Jim and President Trump have been going at it. President Trump has called Jim and CNN fake news, enemies of the people. And again, that creates this hostile First Amendment atmosphere. And we were able to, Jim arrived the day after this news conference. I'll show you, this is the last clip of President Trump. They got into it at this press conference. Let me just get that.
Mr. President, are you worried about indictments coming down in this election? Mr. President.
I'll tell you what, CNN should be ashamed of itself having you working for them. You are a rude, terrible person. You shouldn't be working for CNN. Go ahead.
I think that's not
You're a very rude person. The way you treat Sarah Huckabee is horrible. And the way you treat other people are horrible. You shouldn't treat people that way. Go ahead.
In
Go ahead, Peter. Go ahead.
Jim's defense, I've traveled with him and watched him. He's a diligent reporter.
Well, I'm not a big fan of yours either, so.
Can I ask a question if I can? You repeatedly
You
said,
are the best.
Mr. President, you repeatedly, over the course of the
Just sit down, please. Well, when you report fake news, no. When you report fake news, which CNN does a lot, you are the enemy of the people. Go ahead.
Mr. President.
So we went in, Jim arrived that night at work, and his press badge was taken away from him, and they said, it's revoked. And we felt, and CNN felt, that this was a step too far, because he was being punished for the content of his speech and his reporting for asking tough questions. And we filed a motion for temporary restraining order or preliminary injunction, went in on an emergency basis, and the judge immediately ordered that his press pass be immediately restored. And it was, I think, important to fight back because, as I said, the president's actions explicitly have created this atmosphere that has encouraged attacks on speech and attacks on journalists. And just a few examples of suits recently, Sarah Palin sued the New York Times based on an editorial. That case was dismissed, but it's up on appeal. Taylor Swift threatened to sue a critic. Ronan Farrow tweeted that the National Enquirer, when he was digging up information on them, threatened to come after him and ruin him. People advocated that Justice Kavanaugh sue for defamation. So defamation as a tool of intimidation, of, I think, vengeance, is really has become commonplace. And it's not just limited to traditional news reporting or to print. Now, I really have to give this warning, but I'm going to be playing a clip that includes a giant squirrel who uses profanity. So please, prepare yourselves. But it's all Stephanie's fault, and she cleared it. Mr. Nutterbutter. And John Oliver on his show last week tonight did a piece about this coal baron, coal executive, and he was, critically, he was mocking the coal industry a bit and the health and safety practices of Mr. Murray's company, and he called them a geriatric Dr. Evil. And I'll play the clip and then give you a sense of what happened here.
Which actually reminds me, one more thing here. Bob Murray, I didn't really plan for so much of this piece to be about you, but you kind of forced my hand on that one. And I know that you are probably going to sue me, but you know what? I stand by everything I said. Although, just to reiterate, I do not think you claimed a squirrel talked to you. Even by your standard, that would be a pretty ridiculous thing to say. So I believe that you have never been spoken to by a squirrel. Until that is tonight.
Hey, Bob, just wanted to say, if you're planning on suing, I do not have $1 billion. But I do have a check for 3 acorns and 18 cents.
Oh, that's very nice of you, Mr. Nutterbutter.
It is?
Yeah.
It's made out to eat it, Bob. Never mind, kids for
And Stephanie, did you represent Mr. Nutterbutter in this? Did you tee it up so he would be the defendant? and he's not been sued. But they, you could tell it went on and really challenged Mr. Murray's practices, and it was a state law claim filed in West Virginia State Court, and Stephanie and her colleagues were able to get it dismissed on multiple grounds. That in part because it was a report that John Oliver did very meticulously. I'm sure it was lawyered very carefully, reading from court documents and judicial opinions where there's a very strong privilege that you can report on those things. And also that, that it was comedy, and people know that it's a comedic performance. But it shows that sort of when we're talking about documentary films and other media, that there can be threats that are meant to squelch speech and expressive activity. And a good example of that comes from our friend Katie Couric, she did a piece that focused on the Sandy Hook parents and what had happened to their children and to gun violence. And she had people from a wide array of viewpoints, including a gun rights advocate group called Virginia Citizens Defense League. And she had people from them, and she interviewed them, and sort of the town hall. She asked them their views, and she asked a question of the group, and they edited it so it seemed like there was this long silence, this pause. So it was a pretty novel question. Can silence be defamation when defamation is all about speech? And so the editors, there was nothing false about what they're publishing, but when they edited it, she asks the question, and it seems like they're dumbfounded.
Let me ask you another question. If there are no background checks for gun purchasers, how do you prevent felons or terrorists from purchasing a gun?
So it's kind of interesting. There actually wasn't a pause. They were not sitting there with sinister music coming over them, thinking about the answer to that question. And after the film, I think it was at Sundance Film Festival or other film festivals, there was an outcry and a public backlash. And Katie Couric issued a statement saying that it did not accurately represent the reaction of those individuals, and that and she admitted the segment was misleading. But the organization and two of its members nonetheless sued, claiming they had been defamed. And originally a federal judge ruled that silence basically couldn't be defamatory. The Fourth Circuit Court of Appeal affirmed, so the case was dismissed on the theory that the broader context showed, if you looked at the film, that they actually knew what they were talking about, and that their argument that they were made to look ridiculous and incompetent and ignorant, that you wouldn't have thought that necessarily when you viewed the whole film. But if you think about it, that's a lot for a court to find, that they were really weighing in. That's why the actual malice and the First Amendment principles are so important, because it allows the courts to just come in and say, no, not close enough, we're going to dismiss the case. Where if you didn't have those principles, that would be an issue for a jury, and you'd be subjected to the risk of a big verdict. Another case from the documentary, or at least the something like a documentary, was this R. Kelly docuseries controversy. And this is particularly timely again because the Lifetime Network had this piece prepared about R. Kelly, the R&B singer's many allegations of domestic abuse, kidnapping, sexual assault. So very, very serious allegations made against this individual. And so, that's where, again, journalists, filmmakers, you need to be careful when you're making those sorts of allegations. But if you've got the facts, you should be able to publish them and broadcast them. And here, on the verge of the docuseries starting to air, Mr. Kelly's lawyer sent one of these letters that you just see them all the time, and they can be frightening when you get one, especially if you're just a small filmmaker or you're a journalist at a small publication or something. But anytime, saying, this is false, it's just defamatory, you better not broadcast it, we'll file a lawsuit. But they aired it, and R. Kelly never sued. And of course, he was arrested and charged. And I think he didn't make bail, so he's in prison right now. But in any event, that shows that publishing, when even in the face of these letters, can be important, and it can really chill speech to get one of those letters. There in California, we had a recent decision involving Olivia de Havilland, who's now 102. There was a film on FX Network about her life, and Catherine Zeta-Jones played her in this. It was called Feud, and I just mentioned it in passing because it was really an important First Amendment decision. The Court of Appeal held that whatever the medium, the court said authors write books, filmmakers make films, playwrights craft plays, and television writers, directors, and producers create television shows and put them on the air. or online, and the First Amendment protects all of these things and protects those who are writing about real live people or making a film about real live people in the same way it would if you're doing journalism. So it's a very important legal decision for those of you here who may be making documentaries and the like, where you're really talking about real life events, real life people. And the court said those people don't own the rights to the story about what happened to them, which is really important when you're trying to really capture something that happened in the world. One of the, I think, most interesting but potentially dangerous developments involves a cousin of the tort of defamation, invasion of privacy or false light privacy. There are a couple of versions. And a famous case involved Hulk Hogan and the website Gawker. And Gawker was a sort of irreverent website that really prided itself on doing outrageous things and kind of piercing the elite media world of New York. And they would do outrageous things, including running tapes showing celebrities having sex and the like. And so they obtained a tape that Hulk Hogan in a sexual encounter with between him and the Heather Clem, who was the then wife of Bubba the Love Sponge, who was a radio host that he was friends with, and they posted it. And they posted it on their website, and one of the editors did an article about why sex tapes with celebrities suddenly had become something that people were publishing. And it's unlike New York Times versus Sullivan, this is not the greatest fact pattern to go, fight the First Amendment battle, because it's a much different, it's a much closer call whether this is newsworthy information or public information. But with Hulk Hogan, it was a unique circumstance because he had really kind of made his career, particularly in the later years, about talking about his sexual activity, his marriage, all sorts of things probably most of us don't want to hear about here. And so he had sort of thrust himself, his private life, he himself had made his private life and his celebrity status a public issue. But he lost at trial, and he explained on one hand he took blame. Here's what he said.
And Bubba was there with me. It was really hard to handle the fact that he did this to me. It was. I'll say it.
Do you blame Bubba as much as you blame Gawker?
No, I'm kind of what I blame myself. I blame myself because you're at an all-time low. You have nobody, and my gut was telling me something's wrong. My gut instinct, that spirit of Christ was telling me something's wrong. And I made the worst decision of my life, so I blame myself.
By all accounts, he was an excellent witness, and he had a very creative theory that the Gawker lawyers brought out all this information showing he was saying all these crude and lewd things, and just that made the privacy claim sound really weak. But he argued that was actually Hulk Hogan talking, and that none of that applied to him, Terry Bollea. And so and the jury bought it, and it was a $141 million verdict, even though nothing was false. It was, the tape, his friend Bubba leaked the tape. That's why he said he was mad at Bubba. But it was not a case of following false speech. Jeffrey Toobin in the New Yorker did a terrific piece on this case, arguing that this is a real danger, particularly, let's get out of this sort of lurid area, but where journalists get a hold of really explosive information. There's a case called Bartnicki, really the Supreme Court's last great case. It's from 2001 on journalistic rights that held that if a journalist obtains a document or a tape that was illegally created or illegally obtained by the source, as long as the journalist didn't do anything wrong, the First Amendment protects the right to publish it. And you'll remember the Pentagon Papers case was all about government documents. You couldn't have a prior restraint. In the Bartnicki case, there couldn't be a civil action if the issue, and that was a privacy case, much more boring fact pattern. It was a teacher's labor negotiator was taped on a phone call, and then that was leaked to the local radio. But it was a really important principle because the Supreme Court said if it's an issue of public concern, privacy interests are defeated by the First Amendment's interests in ensuring the free flow of information. So the Bartnicki case was very important, but in the Gawker case, the jury was allowed to hear the case, found this huge verdict, and Gawker went out of business. So it's every journalist and news organization's worst nightmare. A verdict in a civil case that puts them out of business. So it's really it's a unique case, and as I said, a tougher argument where you've got that. It wasn't the Pentagon Papers case, but those are the kind of cases that can create bad precedent. Now there never was an appeal because they went out of business. The case settled, and now we're going to have to deal with the consequences of it. So that brings me really to the last topic I wanted to talk about, the Me Too era and the speech in the Me Too era. Because if you think about it, the Me Too movement is one of the greatest free expression moments in history. It's this remarkable outpouring of speech from women who came forward and talked about wrongs that had been committed against them in all sorts of different industries, the entertainment industry, and the business world, the political world, and then journalists reported that, and in the face of a lot of threats, trying to stop them from reporting it. And these things went back many, many years. It was like unearthing this horrible story of our society, and it all started. I think the Bill Cosby allegations were one part of it, and a couple of rulings in the Bill Cosby world. The McKee ruling that I mentioned, that's the case that went to the Supreme Court. And there, the courts in that case found that since Ms. McKee had sort of injected herself into this public controversy about allegations about Bill Cosby's misconduct, she had become what's known as a limited purpose public figure, and so she had to prove actual malice. The other twist to that case is that her case, so she came forward and made accusations against Bill Cosby. Bill Cosby and his lawyer, Marty Singer, who Stephanie mentioned, put out a press release and distributed a letter that said she was a liar, what she was saying was false, couldn't believe her, and attacking her credibility. The court in the McKee case said, limited public figure, and people need to be able to defend themselves when they're accused of something bad. And I have to say, I do have some sympathy for that notion that these are serious allegations, and they're not always true. And in any event, a person accused of something should be able to say that's false. At the same time, the way they do it is to trash the person, to trash the accuser, to accuse them of just being worthless, lying, awful people. And maybe there's a difference there. But so she comes out and makes her accusation. She's threatened with a suit by Bill Cosby and Marty Singer, who say she's a liar. She then is the one who sues for libel, saying, you defamed me by calling me a liar. So you've got libel claims and speech going back and forth, and it's I think, a new area that we're going to see. So here the court said, no, you can't go forward with that claim. That case went to the Supreme Court, cert denied, no review. Justice Thomas weighs in. Then there was another case, Janice Dickinson, very similar situation. She made allegations. She was a model and said that Bill Cosby assaulted her back in 1982. And in that case, in California, the court said that when she made her allegation against Bill Cosby, and Bill Cosby and his lawyers sent out a press release, and they have a kit for these kind of things. The libel package. Very similar type of letter and press release, I'm pretty sure. That then she then sued again, like Ms. McKee, and the California court said, no, that can go forward. That being called a liar and saying that someone lied about something is defamatory, and so at least at the motion to dismiss stage, the case could go forward. So we have that complex area happening in Me Too, where we want to protect people who want to speak out about wrongs that have been done to them by powerful figures in this country. At the same time, they can harm a person's life to be accused of these things. At the same time, the threat of having Bill Cosby or anybody else in that position of power, like my next guest, go to Harvey Weinstein, to have him, someone like that in a position of power, be able to threaten you with a libel case to ruin your life, it's going to make it less and less likely that more women or other victims or other people who have important information will come forward and speak. And so the Bill Cosby events, I think the campaign of 2016 contributed to the Me Too movement, but it really exploded in October of 2017 when the New York Times ran a front page story about Harvey Weinstein. And there had been rumors for years, or not even rumors, people knew this, that Harvey Weinstein was a serial assaulter of women and was using his position as the most powerful producer and distributor in Hollywood who could get you an Academy Award to engage in improper conduct with women, including some allegations of assault, but also the lesser things, though, that could really harm a person inside, but also harm their career. And Ashley Judd, my client, was really one of the first women to go on the record and both say, I'm going to tell you my story on the record, and it was the lead part of this story, but multiple other women came forward and said, described pretty similar, and some had more egregious activity by Harvey Weinstein, but it was just this horrifying pattern, and so when Ashley told her story back in the New York Times article, and she described it, and I'll play a clip for you, one last clip, where she can tell it in her own words. But the gist of it was that back in 1996, when her career was really just taking off, she'd been in a couple big feature movies, and Harvey Weinstein, she got word, wanted to meet with her about possible work. So she and her father happened to be in town, went to the Peninsula Hotel, and she expected to meet in the restaurant. And instead, the assistant to Harvey Weinstein said, no, he'd like to meet with him in his hotel room. And she gets up there, and he's in his bathrobe, and he asks her if she wants him to give her a back rub. Will he watch her take a shower? She's feeling like she's about to be assaulted. She wants to get out of there, and she flees. She comes up with excuse and flees the room. And about a year later, she was in negotiations, and she felt she was on the verge of being offered her choice of one of the female lead parts in the Lord of the Rings trilogy. And the meetings went great. She thought she was going to get the job, and then she never heard back. And so for years, she wondered what had happened. Well, Peter Jackson, the producer and director and creative genius behind the Lord of the Rings, when he saw the New York Times article, he realized what had happened, because he, on his own, we had no idea this was going to happen, did an interview where he said when he saw what Ashley Judd told the New York Times and what Mira Sorvino told the New York Times, she had a very similar story, an event that happened to her. She was also up for a part in Lord of the Rings. He realized that Miramax and Harvey Weinstein were trashing them, retaliating against them for not having succumbed to his sexually inappropriate advances. And so he apologized, and that's the first time Ashley knew what had happened. And so the lawsuit we filed keys off of that fact. Even though it happened many, many years ago, statutes of limitations, which would normally limit you to a 3-year period after the sexual harassment or assault, don't start to run until you know or should have known what happened. So our argument, and the judge ruled in our favor on this, it was a big ruling, was that Ashley Judd did not know she had been retaliated against, that she had been defamed, because that was our argument. What Harvey Weinstein told Peter Jackson was that don't work with Ashley Judd. She's a nightmare to work with. I had a terrible experience with her. And so Peter Jackson said, well, Harvey Weinstein's telling me this. I'm not going to do it. So that's why he did not cast her. And so the court held that we could proceed with our case. And another tie-in to what we're talking about here is this use of libel claims and defamation threats to try to stop publication. they pulled out all the stops to try to stop the New York Times and the New Yorker, which published another, right on the heels, they were all working on this at the same time. The New Yorker published another blockbuster about all these women saying, this happened to me, it ruined their lives. And I've talked to a number of Mr. Weinstein's victims, and these are famous people, not so famous people, they maybe would have been famous. Their lives were ruined. And in some instances where Mr. Weinstein took explicit action. But to stop that story from coming out, they threatened to sue. They even went so far as to hire this company called Black Cube. And Ronan Farrow's story from November 6, 2017 in the New Yorker is worth a read, because they hired this Israeli intelligence / investigation firm called Black Cube, and they were former Mossad spies. And so they deployed them in all these different ways to gather information about what the New York Times was reporting, what Ronan Farrow was reporting, and what the women were saying. They even went so far, this is one that just floors me. Think how awful this is. Rose McGowan, the actress, had claimed that Harvey Weinstein raped her. So Black Cube, I don't think there's any dispute they actually did this, they had one of their agents, a woman, pretend to be sort of a victim's rights advocate or something, and befriend Rose McGowan, and they actually they knew each other, to try to figure out what she was telling the New York Times and others. And so that all came out, that there was this campaign to squelch speech about really important issues that involved this kind of nefarious, intimidating activity. So Ashley Judd approached me, and it all kind of, in part, ties back to my tweet about President Trump, but she said she wanted to bring a suit that would be bigger than, actress. She's doing fine. She's a wonderful person. She's an activist. But she wanted to bring a place that would be a platform to say, this isn't just about actors in Hollywood, but other women and men, for that matter, who are in sort of outside the traditional employee-employer circumstance, but who are victims of sexual harassment and whose careers are derailed. Ashley didn't get that job in Lord of the Rings. That was this huge, it won like 20 Academy Awards. It was, blockbuster. It would have been, her career is terrific, but her career would have been at a whole another level, we contend in the lawsuit, had she gotten that role. So let me just play her describing what it felt like, and I can give you a quick update on our case.
The ABC News exclusive, actress Ashley Judd fighting back against disgraced movie producer Harvey Weinstein. Judd filing a new lawsuit claiming he damaged her career, detailing how it was he blocked her from getting major movie roles. And she says it was retaliation after she rejected his sexual advances. ABC's Amy Robach with the one-on-one.
Tonight, actress Ashley Judd sitting down for her first TV interview after filing a new lawsuit against Harvey Weinstein.
You are now filing this lawsuit against him. Why now, and what do you want?
So what I want is for Mr. Weinstein to be held accountable for his illegal conduct.
One of Weinstein's most vocal accusers now suing the disgraced former movie mogul, claiming he hurt her career for decades, retaliating against her for rejecting his sexual demands in an LA hotel room back in 1997, where she says she narrowly avoided sexual assault.
It is now been found.
Judd says a year later she was in talks with director Peter Jackson to play a role in the blockbuster trilogy, The Lord of the Rings. Weinstein allegedly telling filmmakers she was a nightmare to work with and should be avoided at all costs.
My rebuffing illegal sexual harassment in a hotel room, that Harvey Weinstein lied about me and interfered with my economic opportunity and blocked me from being cast in Lord of the Rings.
In an interview, Peter Jackson saying he'd been fed false information that he now realizes was a smear campaign in full swing.
We heard directly from director Peter Jackson. He says that Weinstein torpedoed your incredible professional opportunity to star in the Lord of the Rings franchise. What was your reaction when you heard him say those words out loud and publicly?
I felt very sad when I heard that. I had a lot of processing to do. I felt I'm going to get upset about it. It's very upsetting. And then all of a sudden, mysteriously, we never heard back from the
You thought you were going to be used in this franchise.
I was being invited to consider which of the two roles I preferred.
And then all of a sudden, poof,
it was just proof. I was being maligned and defamed.
Judd's attorney acknowledges there are a lot of people seeking damages from Harvey Weinstein.
The evidence from Peter Jackson, we have got strong legal theories, and I think we're going to collect money and we're going to put it to a good cause.
Judd said she will donate any money won in this civil lawsuit to the Time's Up movement. Weinstein has denied any allegation of sexual assault and has not yet commented on Ashley Judd's lawsuit. He has said in the past that while he and his brother Bob were executive producers of the film, they had absolutely zero input on casting. David?
Amy Robach tonight, and Amy, I know you have much more of your exclusive interview with Ashley Judd first thing in the morning on GMA.
So our idea is we're bringing this claim for a lot of money, and Ashley's going to give whatever she recovers to Time's Up or some other organizations that support women being able to fight these sorts of cases. And Time's Up is really meant not to focus on helping actors and actresses and wealthy people, but individuals throughout the workplace or in different professions. And we're going to give any legal fees we would otherwise have obtained to do the same thing. So it's basically a pro bono case, but it's a platform. With someone like Ashley Judd, we can really publicize these issues. The judge, tying it back all together here, how can I represent someone in a defamation claim, in a defamation case? Here it really is easy, because this is what defamation law is meant to do. It doesn't involve a statement about a public issue of public concern. It was a private, secret trashing of someone's reputation in order to punish them for not engaging in sex with you. So it's not an issue that will chill important public speech about public figures and public issues. And so it seemed to me to be exactly the kind of case where, if there are going to be defamation cases where they can serve an important purpose, this was the case. And so the judge denied the motion to dismiss. Harvey Weinstein argued, well, this was just opinion, that kind of like in those other cases, wasn't a fact. But the judge said, no, you said she was a nightmare to work with. You said she should be avoided at all costs. He also had said that he had a bad experience with her, which when her story came out, he said, oh no, I thought she was great. I liked working with her. So he kind of admitted that if that was said, as Peter Jackson said it was said, it was false. So I think we have a really powerful claim, and the case is right now scheduled for trial in January 2020. So to conclude, we live in a world of this just amazing amount of speech that private individuals can engage in. A tweet from somebody who is a private person that doesn't have a public platform can go viral, can get out there in a second. People's reputations can really be damaged by false speech. So I think as a First Amendment lawyer, I always try to keep that in mind. It's great to cheer for the First Amendment, but people's lives can be harmed. And so you need to keep that in mind, both when you're determining whether something should be published or something should be aired. We need to be careful and do the homework and check the facts. But at the same time, I think I'm going to call Justice Thomas and double down on him. I think the First Amendment protections need to be expanded. We need to leave room for cases like Ashley Judd's case or other claims. There are cases, if you think back on the Duke lacrosse team or the Rolling Stone piece about the UVA, at UVA, and where it turns out there were false accusations. And so I probably wouldn't take those cases, but there are times when people are harmed. But that said, today the speech comes so fast, and private individuals can. I'll finish with this. One of the rationales for limiting Times versus Sullivan to public figures is that a public figure has a platform where they can respond. They can get a lot of attention, and they can just respond and then cure the false speech. Well, now private citizens can do that. If the issue is one of public concern, whether it's a private person or a public figure, I think that the actual malice standard should apply. And I think that will provide enough protection. And even a private individual, you saw in the Covington, Kentucky, students who were at the Lincoln Memorial and were with the Native American elder, or that episode, those students, they disagreed with the way they were being characterized. Within an instant, there was this explosion of people saying they were misportrayed. One of them still filed a big lawsuit against the Washington Post. But there is a platform. So false speech or allegedly false speech can be corrected in our new world of speech. So I think we need stronger protections, but we need to make sure that people can get damages when they deserve them. But when we're talking about issues of public concern, that's where the First Amendment is triggered in a way that should protect against libel suits absent meeting the rigorous actual malice standard. Because at the end of the day, the First Amendment is fundamental to our democracy because it's intended to let us all get the information we need to make decisions about how we govern ourselves and how we order our society and how we live our lives and how we construct our lives. So where we have these threats of lawsuits and weak laws and watered down laws that allow powerful people to squelch speech, it hurts our democracy. Thank you very much. I think I left time for a question or two.
Yeah, we have about 15 minutes. We want you to be able to go outside and talk to each other or talk to our guests. So we have microphones where you can go if you have a question so that everybody will hear what it is you want to ask about. If anybody has a question, I can start to give you time to get to the microphone. The question I have, and I don't want you to bring it down to your particular case, but is there a difference between something that's newsworthy and something that is a matter of public concern as you seem to define it?
It's a really good question. I mean, I think one of the big issues that this Gawker case kind of reveals is that what is the definition of newsworthiness when we're in a celebrity culture where there's constant focus on reality TV. Reality TV can have such a huge effect on our democracy, and people allow their intimate lives to be followed, and it becomes something that people are interested in. The public is interested in it. And I think different news organizations, if we're talking about news organizations, have different standards. Well, to one, it might not be newsworthy, and it really is something that the journalists and editors and reporters should get a lot of deference on. And so I think that the public concern, I think it's really going to be a battleground, this question of, can it be newsworthy if it's not a public concern or vice versa? And I think on the newsworthiness question, there should be a lot of deference to the journalists. That's why the Gawker decision is, I think, really troubling. Yes, sir.
Yes, thank you very much. We saw in the Gawker decision that Peter Thiel was litigation funder. Are you seeing litigation funders getting involved on behalf of plaintiffs in defamation suits and or political interest in involved on behalf of plaintiffs in defamation suits?
I'm so glad you asked that because that was another really troubling kind of aspect of Gawker that I couldn't have imagined 20 years ago, that the Peter Thiel, billionaire tech executive, it turned out he had been funding the Gawker suit all along. It wasn't known before the verdict. And he wasn't just doing it because he felt bad for Hulk Hogan. He was doing it because he had his own vendetta against Gawker because they had run critical stories of him. They had, I think, outed him as being gay when he didn't apparently want that to be known. And so he literally wanted to punish Gawker, so he funded this lawsuit. So it adds a dimension in defamation cases that you could have a wealthy person who doesn't even have a claim finding someone else who does and funding it. And here, it's, again, I keep saying the nightmare scenario, the lawsuit put that news site out of business. And so that is, I think, really dangerous. We do see a lot more litigation funding in cases where it seems to skew the incentive structure, that lawsuits that really should be someone's really hurt and they don't have enough money or they can't get a great lawyer, their cases don't go anywhere. But other cases where the calculation is such that a funder will come in, those can go on forever, they'll fight to the bitter end, and then the actually injured people are no longer even in the case. So they'll sort of, their case will be sort of sold off to the funder really takes it over. So we've been seeing more and more of it. It's very prevalent in commercial cases, and it's also in cases, sort of where there's a big verdict against, part of my other practice, I represent a lot of large companies, there'll be a big verdict, and then the funders will come in, and so suddenly the ability to resolve the matter changes because you have a third party who's really just in there sort of gambling a bit with what's happening. I think it can serve a valuable purpose where there's someone needs, they have a legitimate claim and they want to go forward, but it has really gotten complicated. And in defamation cases, it's downright scary. Thank you.
Thank you.
Yes, sir. Mr. Sneed.
The Mueller report is forthcoming and leaked to the New York Times and published. Any thoughts on how the courts might deal with that?
Yeah, it's very interesting because I think that falls into the classic bread and butter category where if someone leaks it and the New York Times or somebody else gets a hold of it and they didn't violate the law, then they have, to my mind, absolute right to just publish it. And the Pentagon Papers case, as I mentioned, was a prior restraint case where the United States government tried to stop the publication by the New York Times and the Washington Post of the Pentagon Papers, and the Supreme Court said, no, the proper remedy is if something is being published by you is to sue after the fact. So then that brings us to the question, that's the sort of, is there a defamation claim? But the Supreme Court in that Bartnicki case I mentioned said, no, if you didn't do anything wrong, and the information is true, and in the Mueller report, you'd be reporting on an official government document, I don't think there'd be any claim for it, but we'll probably see threats to go after anybody who gets a hold of it. Anyone else? Yes, sir.
The Ashley Judd case, is it a pure defamation case, or are there other claims in there? Because when I think back to my time as a lawyer here in Philly, I probably would have been a tortious interference with prospective contract or something like that, not really a defamation, not pleaded as a defamation case necessarily.
I like the way you think. Yes, yes. We have a tortious interference with prospective economic advantage, and our argument is, you engaged in wrongful behavior meant to disrupt this relationship with a third party for your own malicious, bad faith purposes. Exactly. We also have a claim for, there's a California statute that we argue was meant to apply in exactly the circumstance, sexual harassment or retaliation in professional relationships, so not in employment relationships. We argued to the district court that this was a professional relationship. He was a studio head and she had a relationship with him. The district court found that the statute did not apply to our circumstance. The legislature then amended the law to explicitly say that it applied, and the district court found that it wasn't retroactive. So we're trying to appeal that to the Ninth Circuit, because part of our effort here is to, again, use this case as a platform to make sure there's a fair system. Oh, yes.
You have a lot of technology here. So a lot of times people are videotaping events, but there are phones. They're not even involved necessarily. So for example, the Covington case, there was a lot of different video on that, taken from different perspectives. I wasn't clear on how you were seeing the lawsuit with regard to that, because that it can be distorted because of private citizens or other people just taking pictures with their phone.
It's really a complicated thing. I think you're absolutely right. And I think looking at the reporting was in a sense reporting on what the videos showed. So they were accurately reporting on what they had. But it really does change our world. And in that sense, just being sympathetic to the students for a second, that happened maybe how it played, all of a sudden it's a global story. And so that's why, you don't have the full picture. So I think the reporting, I think journalists are, going to get better and better at this, I hope. But it's a complicated thing because they should be able to report on what a video shows, but put it in the proper context. This was one angle, and particularly then when more information came forward, most of the news organizations that had been out there in front, then they published stories about the other angles that showed something different. So then you get the full body of information. And I think that's the way it's supposed to work. But I do think there needs to be just more editorial attention paid to the fact that a tweet isn't necessarily news, or the fact that somebody in my old hometown of Bismarck, North Dakota, something weird happened at a supermarket with a private individual, that becomes a global story. I think we need to. It's a different perspective now with the ability to take these videos and then post them and circulate them globally. Yes, sir.
And what happened to Miss Winter, to James Risen, and why did the Obama administration file so many claims trying to repress reporting?
That's an issue that's near and dear to my heart. Subpoenas to reporters for getting leaked information can also have the same kind of chilling effect. And I was sharply critical of the Obama Justice Department and the administration because they were sort of out of control. Jana Winter was in one of those cases in Colorado, and then James Risen. I represented Matt Cooper in Time Magazine. This was back in the Bush administration. But the James Risen and those issues, the Justice Department was just, they had a search warrant for James Risen, which is really extraordinary. They had phone records from the Associated Press, and I think I wrote a piece in the Wall Street Journal saying they had lost their way on the First Amendment. And they have guidelines at the Justice Department that say, before you subpoena a reporter, you need to jump through these hoops. It has to be crucial. And I think they just weren't applying them. The good news is that they revised them after all that and then sort of stepped back. But Risen was never able, it went down to the wire. And in those subpoenas to reporters, all of a sudden you're using the press as your investigative tool if you're a prosecutor. And then sources won't talk to you. Professor Austin, we were talking about this with, if you're filmmaking, if the people you're talking to think, well, they can come and get your film and use it in a criminal trial or people are going to be less likely to talk to you. The big problem is, at the federal level, there's no federal, we call it reporter shield law. And all of us have been trying for years. Congress, Mike Pence was very supportive of it when he was in Congress. And so that was a glimmer of bipartisanship, but could not get a federal shield law passed. The Supreme Court in Brandsburg versus Hayes, again back in 1972, which should have been a good time for this rule to get established, rejected a reporter's privilege under the First Amendment, at least in the grand jury context. Many states have good laws that protect against subpoenas to reporters. There's nothing at the federal level other than the good graces of the Justice Department. Their guidelines are not enforceable, the courts have held. So you just have to hope that they do the right thing. And I think the Obama administration made the wrong call on a number of those, and it was bad for the First Amendment. Thank you for bringing up my other favorite topic.
What happened to Winter and Risen? Were they
their sources were protected, which was good. Yeah, ultimately, and the judges kind of took it right down the wire, but after a long time, but they were not compelled to give up their sources, which was great.
I want to thank you.
Thank you.
For a provocative lecture. For setting us on the right course. I think you presented the law in a way that was accessible for those of us who have forgotten about defamation until very recently.
Well, thank you so much.
You've been quite enlightening in terms of what we will know going forward, given the public events that are likely to happen.
Thank you so much.
You can join us, and thanks again.
My pleasure. Thank you all.